Archiving started.
Welcome to our fifth presentation relating to Chapter 4, the chapter that talks about the sources of American law. I apologize for the abrupt ending of session number 4. I hit the wrong button on the computer and mayhem ensued, and so there was probably about 5 or 6 minutes of dead time at the end. I really wasn't saying anything, but unfortunately that doesn't allow me to edit it after the fact. So if you were wondering what was happening during those 5 or 6 minutes, honestly, nothing was happening other than me scrambling to figure out how I undo what I did. And so anyway, that's the backstory about that. We were talking about constitutional law, so let's go ahead and return to that topic. We're going to go ahead and get to the slide that we're on. We were talking about the First Amendment when we were last together, and here we go. First Amendment. We talked about how freedom of religion, freedom of speech, freedom of the press, the right of people to peacefully assemble and to petition the government for redress are covered in the First Amendment. The Second Amendment has to do with the right to bear arms. This obviously is also a controversial amendment. There's differing interpretations about what Amendment 2 means beyond the scope of this course, but if you have an interest in this topic, it's interesting to read both perspectives, and not that there's just two perspectives, but the two categories of perspectives on what the Founding Fathers intended and or what the most appropriate interpretation of those words are today. And then Amendment 3, of course, this one isn't really a factor in our lives today because obviously we don't have quartering of soldiers in people's private homes, but this was a major concern that our Founding Fathers had because of situations that arose when they were part of Great Britain. It's still part of our Constitution, though, even though it's not a gripping issue. I have some of the amendments in red because these are amendments that have to do with the rights of the criminally accused, and these are the ones that you're most likely to find on tests. So I wanted to flag those of special interest, and you can see not only is it red on the slide, it also says know this one, know this one. Now, of course, I don't mean that you shouldn't know the first three or subsequent ones, but these are the ones that are especially going to be the focus of testing. So be sure that you know that the Fourth Amendment has to do with search and seizure, and that this has to do with unreasonable searches and seizures, and it has to do with the requirement that there be warrants and that probable cause has to exist. Those topics that we find in Amendment 4, and then in the Fifth Amendment is a kind of a grocery list of different rights, very important rights. The right to due process. In fact, there are 2 amendments to our Constitution that talk about due process. This talks about it in respect to criminal law. The 14th Amendment, which we'll talk about in a few minutes, has to do with respect to civil law more. Then we talk about double jeopardy, and this is the right not to be prosecuted criminally twice for the same behavior. Again, each one of these topics I could talk, or somebody who's trained in this area could talk for hours about these topics. So I'm just kind of grazing the topic. Then we have the right against self-incrimination. And by the way, if you have an interest in these topics, we have a criminal law course that's LGLA 2313. And we will spend a lot more time talking about each one of these amendments in more detail. Then we have the right against self-incrimination. An important part of this right is found in the U.S. Supreme Court case Miranda. You may have heard about Mirandizing someone. In police dramas have seen police officers say things like, you have the right to remain silent, all that kind of stuff. Well, those have to do with the Supreme Court case Miranda, which was an extension of the Fifth Amendment's right against self-incrimination. Then there's also the issue of eminent domain. Let's imagine that we go back 60, 70 years in time, and I happen to own some land here in the location that we now describe as being the intersection of Spring Creek and 75. I happen to have a farm. Maybe I have cattle that I'm running. Anyway, that's the place that I have. And let's say the U.S. government comes to me and says, we're planning on building U.S. 75, and we're going to build it through your land, so we are going to be buying a portion of your land. Well, I might say to the U.S. government, well, I don't want to sell it. This is my land, and it's been in my family for generations, and I want to keep it all together, so no thank you. I don't want to sell. Well, the U.S. government could use its eminent domain power and say, well, guess what? You don't get a choice. We're going to buy it from you. We have to offer you just compensation. By the way, another name for this is the takings clause. You'll see that also used sometimes. Where we have to give you just compensation, but we can insist, because it's for a public purpose, we can insist that you sell the land to us. And so under those circumstances, I would be entitled to the fair market value of my land, but I would not have the right of saying, no, thank you, I want to keep my land. Amendment 6 is also in red. It also says no, this also has to do with the rights of the criminally accused. And again, we'll see here that I have the right to a speedy and public trial. The idea behind many of these protections are that the government has a lot of power. They have a lot of money, and they have the ability to imprison people, and they have the ability to execute people under certain circumstances. And so when the state is trying to take away your liberty, you are at a tremendous disadvantage, even if you're a wealthy person. Even Bill Gates doesn't have the kind of resources to compare against the federal government. And certainly the average ordinary citizen doesn't have it. And so one of the tasks of our amendments is to kind of level the playing field between the power of the state, and when I say state, I mean the power of the government, not necessarily the state government, but also the federal government, and the power of the individual. So the individual has a right to a speedy and a public trial. Things can't be handled secretly. And once, of course, I'm being accused of a crime, my reputation is affected. Maybe I'm in jail during the development of the case, and so I'm not able to earn an income, and I'm, in some sense, suffering a consequence even though I haven't been convicted of anything. And then I'm entitled to an impartial jury. Again, the state can't decide who's going to decide my fate. The citizens, people who aren't necessarily employed by the state, will decide whether I'm guilty or not. And this actually has to do with grand jury. And I have the right to confront witnesses, to be present when they're presenting evidence. And I also have the right to assistance of counsel. Initially, this right was interpreted to mean if I had the wherewithal, the financial resources to hire counsel, then I had the right to hire counsel. But after the Miranda decision, and if you've ever read Gideon's, Gideon decision. If you've ever read Gideon's Trumpet, which is a book by Anthony Lewis, I highly recommend that. It's an excellent book, and it was made into a movie. I believe Henry Fonda played the role of Mr. Gideon. Anyway, his case changed the law in the United States. Mr. Gideon was a person of very limited means and limited education, and he sought to have counsel appointed to him. After all, the district attorney who was representing the state was an attorney and knew how the system worked, but he, when he was having to defend himself, wasn't in a position to know what objections he could make or know how to put evidence in the record, and so it was a very uneven playing field, and so he requested the appointment of counsel. Well, of course, the judge said, well, yeah, you have a right to counsel. That's protected under the Sixth Amendment, but you have to pay for it yourself. Unfortunately for Mr. Gideon, he lacked the economic resources to do that, and so therefore he did not get counsel. But the U.S. Supreme Court said, hey, if you don't have the economic means, then you really don't get to participate in the rights afforded to the accused via the Sixth Amendment. The vast majority of criminal defendants don't have the economic means to hire counsel. About 80% have counsel appointed for them, being in the same situation Mr. Gideon did. And nowadays, after the Gideon decision, which was either in the late 50s or early 60s, they have the right to the appointment of counsel at no cost themselves if they are indigent, and if they're convicted, they might have to serve a significant time in prison or in jail. Then we have the Seventh Amendment. Again, I don't have this one in red, so it's not quite as important to know about it. It has to do with civil cases. You have a right to trial by jury in civil cases. And you can see this is one of these examples that something very silly happened. We talked about how a constitution ought to be broad brush strokes, but in this case, our founding fathers did not follow that advice. So they said, where the value in controversy shall exceed $20. Well, back in late 1700s, $20 was a lot of money. Nowadays, if you see someone over $20, you're like, well, really? You're wasting my time over $20? So it hasn't been adjusted for inflation. So this is an example of kind of bad drafting by our founding fathers. It should have not been a specific amount, or it should have been adjusted for inflation or something like that. Now let's go to the Eighth Amendment. This is the Cruel and Unusual Punishment Amendment. So this is the one that, for example, precludes physically painful punishments. We don't have caning, or we don't have the stockades anymore. You can't have those types of punishments. Some people think that the death penalty is a cruel and unusual punishment, but so far our U.S. Supreme Court has not reached that agreement. And, of course, at the time that our founding fathers passed the Eighth Amendment, capital punishment was the law of the land, so certainly our founding fathers at the time that they passed this amendment would not have considered capital punishment, at least handled in a reasonably humane manner, to be cruel and unusual punishment. In addition to prohibiting cruel and unusual punishment, excessive bail is prohibited and excessive fines are prohibited, and this actually applies both in the criminal and the civil context. Let's go to the Ninth Amendment. This is the construction of the Constitution. And here we have this word enumeration, which we talked about before. The enumeration of the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. So what it's saying here is that just because in the Bill of Rights there's no mention of a particular right, that doesn't necessarily mean that the people don't have that right. This constitutional amendment is where many people find the notion of privacy rights. You won't find the idea of privacy anywhere directly stated in the U.S. Constitution. But if you combine this statement with the Fourth Amendment and with other provisions, it seems like our founding fathers were worried about the topic of privacy. And so by arguing by analogy and kind of by creating an expansive view of these rights, some constitutional scholars, including some on the Supreme Court, have found that there is, in the penumbra of the Bill of Rights, this idea of privacy rights. Then we have the 10th Amendment. This is the last amendment in our Bill of Rights, because remember, 10 fingers, 10 in the Bill of Rights. And this is the powers not get delegated to the United States by the Constitution. So we're thinking here Congress, can't write here very well, nor prohibit it by it to the states, are reserved to the states respectively or to the people. And this is where we find the notion that if the Constitution hasn't given Congress a particular right, then guess what? Congress doesn't have that particular right. Congress is supreme where it is enforcing an enumerated right. Where there is no enumerated right, it has no power whatsoever. So those are the first 10 amendments, but we're going to talk about the 14th Amendment. This is one where we have that due process language in it. This is actually an interesting amendment. It's not part of the Bill of Rights because, of course, it's the 14th Amendment, but it has many similarities to the Bill of Rights. Some people kind of consider it a mini Bill of Rights on its own, or certainly connected to, at least in terms of its focus, connected to the same ideas that we find in the Bill of Rights. And this is actually considered one of the Reconstruction Amendments. It was right after the Civil War ended in 1865, and this was focused on addressing some inequities that had come to light or were continuing to exist, especially in the southern states, although by no means exclusively in the southern states. And it was designed to ensure that African Americans, the former slaves, were given the rights that they should have as citizens of the United States. So we find the first clause, all persons born or naturalized in the United States, and of course the African American slaves were born in the United States, although they were born enslaved, and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they live. The focus of this was again on the African American newly liberated slaves, but it also perhaps was focusing on, to a lesser degree, on the Chinese Americans who had immigrated and had been denied in many cases citizenship in the United States at this time. Nowadays, this provision is more important, except from a modern day perspective, when we talk about people who are born here but whose parents may not be citizens. For example, an undocumented person who is here who gives birth to a child Even though that person did not have a lawful reason to be in the United States, if she gives birth to a child, that child is automatically a citizen because that baby is born in the United States. And so that's the basis of that citizenship claim. And this is what they would point to support the argument that they are in fact U.S. citizens. And again, it's not that controversial that they would in fact be U.S. citizens. Let's look at the next provision. No state shall make or enforce any law which shall abridge the privileges and immunity of citizens of the United States. This is the part I want to focus on. Nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within this jurisdiction equal protection of laws. Again, this is focused on the fact that some states were passing laws that seem to favor white people over African American or over other nationalities. And so this is designed to address some of those wrongs. I don't know that it was a very successful tool, but it continues, of course, to be the law in our country. So that's information about the U.S. Constitution, but we're not only focusing on the U.S. Constitution, we're also going to talk briefly about the state constitution. As I said before, virtually every state, perhaps every state, does have a state constitution. Certainly Texas has a state constitution. A state constitution may not conflict with the U.S. Constitution. If there is a conflict, of course, the U.S. Constitution controls. So that part of the state constitution would be held to be unconstitutional under the U.S. Constitution. As we said before, any powers that the U.S. Constitution does not give to the federal government are reserved for the states. And there are areas in our legal system where the states are kind of considered the specialists. An example would be in the area of public education. Yes, the federal government has some role, but historically it is primarily a role of the state governments to be involved in education. Some other areas would be maintaining the roads in a particular state, maintaining zoning rules, maintaining the public health and safety in a particular state. That would be primarily a focus of the state government. All the laws about family law, for example, who can marry, how a divorce can be entered into, how is child custody established, all those things are going to be, you're going to look to state law to find those. And, of course, the state constitution is going to be the supreme law in that particular state. And the best state constitutions work like the federal constitution. They paint in broad brush strokes the general ideas of the state without going into the nitty-gritty details, which are best handled through legislation. Having said that, state constitutions oftentimes get into much more nitty-gritty stuff than federal constitutions. And in some sense, that's not bad because it's a lot easier to amend a state constitution, typically, and certainly it's easier to amend our state constitution than it is the federal constitution. So if you do get too specific, all you have to do is have the citizens of the state vote during an election to make a change to that particular law. And we will go over the true-false in class. I'll move on to the next one. So we've talked about, here we go, we've talked about the common law as a primary source of law. We've talked about, here we go, this pen doesn't work too good on this. So we're talking about primary sources of law. And we've talked about the Constitution. And now we're going to talk about the statutes. We talked about constitutions, both federal and state, and now we're going to talk about statutes. And we're going to close with the discussion of regulations. These are all primary sources of law. So right now we can check off the first two categories that we have completed these, and we will continue on to statutes and to regulations. Here we go. Statutes. What is a statute? Well, one good definition from the textbook is our written laws enacted by legislative bodies acting under constitutional authority. And of course we have two sets here. Actually we have three sets. We have federal statutes, laws passed by Congress and signed by the President. Of course, they're enacted by the U.S. Congress. And let's pause for a second and talk about the checks and balances that we have in our system. I'm having a little bit of technical difficulty. I'm having a little bit of technical difficulty, so I'm going to go ahead and conclude this presentation.